let's move on, because this is a very important story. It could even mark a turning point. And it comes with judgment on seeking relief, bail that is, tomorrow in court. And it's not what under the scanner Delhi excise policy like to press leader and legislator Kavitha, but also passed some searing comments against her that will worry the others, virtually confirming the ED had been able to prima facie establish that she was involved in the commission of alleged offences. The court also said that she had destroyed evidence, viewers. Of material evidence by formatting her phone before joining investigation and after being served with notice requiring her to do so, along with the digital devices which stands established by way of the forensic report, but has also been instrumental in influencing with in the case the relief prayed for is granted to her. Very, very significant, viewers. Why would you witnesses influence them if you had nothing to hide? Why would you want to destroy evidence, digital evidence, which is if you had... Then, viewers, order para 48 says this: the material placed before this court in the course of arguments prima facie towards an act alleged offences, also towards a deliberate act of causing destruction of evidence despite attempting to influence witnesses of the case. Viewers, influencing witnesses, destroying evidence. The court orders wider implications to be base of the influential South lobby that paid kickbacks allegedly to the AAP to the tune of 100 crores. If the ED has proof of this prima facie, it might become difficult for the AAP to distance itself from the alleged scam that allegedly leads to the door, at least that's what the ED says, of the two most senior bosses of the party. Viewers, it's not as if the courts have been particularly lenient towards the AAP either. The court has taken cognizance of charge sheet, prima facie accepting the ED case. On March 27, the Delhi court rejected Arvind Kejriwal's bail plea, pronounced an order on granting him bail. Another hard fact, viewers, and I always bring you facts to you. The trail of 338 crore against Manish Sisodia existed, prima facie. Hard fact 5, the court denied bail to Sisodia at least 5 times and Vijay Nair at least 2 times. Viewers, let's open this up. This is not looking good if you look at the wider implications. Now, I want to begin with Mr. Ravula Sridhar Reddy, leader of the BRS. Now, sir, it has always been maintained by you that this case is a witch hunt, that the Enforcement Directorate has been, tweak, whatever, by the Prime Minister and his government to go after opposition leaders. Today, look at what the court is saying against Ms. Kavitha while denying her relief. Says she, it appears that the applicant not only engaged in destruction of material evidence by formatting her phone, but has also influenced witnesses, and there is a very likelihood of her continuing to do so. Why is she doing these two things?
See, is it a final verdict that the court has given? Only before the denial of a bail, they would have made these observations. But the trial will go on. Investigation on this, which was stated with due respect to the judiciary and court, whatever as media...
forget the newspapers. You don't have faith in the newspapers either, especially mainstream. So I'm asking you, Mr. Reddy, please, I'm asking you the question again. You allege, Ms. Kavitha has also alleged that this is a witch hunt. Now I'm asking you, sir, if it is a witch hunt, if Kavitha has nothing to do, therefore, today, pulling her up for destruction of material evidence by formatting her phones before joining investigation and after being served with notice requiring her to do so, and most importantly, sir, instrumental in influencing witnesses, and there is every likelihood of her continuing to do so. Can I ask you, sir, why?
Rahul, whatever the documents or the proof, whatever the ED claiming to be, based on the these documents produced before the ED, produced before the court by ED, court would have made some observations, and at this juncture they have denied the bail. But the investigation is not completed. Nobody is convicted yet.
Can I ask you a question, Mr. Reddy? If tomorrow she is given bail, would you say that this is a sign of her non-involvement, even though the investigation will continue?
Yeah, of course, yeah. See, a bail is
Right.
a rule and jail exception. It was said.
So I'm asking you, Mr. Reddy, if she gets
They are
bail
bold
tomorrow,
enough.
will you be triumphant and say, see, we told you the case is hollow? Or will you say, no, 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 the case has to still play out. She is still, under the radar. We can't say that she is innocent, so we will comply.
Rahul, we are matured enough. We are not like few other political parties where just by a denial of bail, they confirm all the accused are criminals.
Okay.
We can say that the investigation will still continue.
Okay.
And we will try to face the legal battle and definitely will prove our innocence in the entire field. So,
Dr. Ranganathan,
now,
I suppose
at
today...
the same time,
Yes.
now at the same time,
Yes.
ruling party leaders and few other political party leaders jumping to the conclusions and deciding and giving judgments. All the accused are criminals.
Okay.
Kejriwal is a criminal. Kavitha is a criminal. Whomever is...
Well, don't forget that in this matter, the Congress has also had to say a little bit about K. Kavitha ji and her involvement. So, that is a party that shares, anyhow, the opposition space with you. May not be an ally, but it has. Anyhow, Dr. Ranganathan wants to come in, and after that, Tom Vadakkan, and of course, the AAP sympathizer.
Yes, Rahul, I have great respect for Mr. Reddy. He is very erudite and intellectual. But I just want to say this, without casting any aspersions on what he said, we should all must avoid muddying of waters. Now, it is no one's grouse, and Mr. Reddy is right, that the trial is not yet finished. It may be that Ms. Rao would come out unscathed and proven innocent. Absolutely. Absolutely. But he must also admit that the trial that was limited to her giving bail is finished. That is why he is muddying the waters. The judgment today pertains to whether she should be granted bail or not. That trial is finished in a very limited sense. And that trial went against her. Why? Because the primary conditions for giving bail is whether the accused, will that accused destroy evidence A, or B, influence witness. What did the court say? I want to ask Mr. Reddy. I want to ask him, is that trial of denying bail finished or not, Mr. Reddy? Yes or no?
Of course, yes. I mean, today.
Thank you. Thank
The
you.
regular
That's why I
bail.
respect you. That is why I respect you, sir. That's why I respect you.
Mr. Ranganathan, only one intervention. This is only for an interim bail. The regular bail plea is still pending for 20th. And she again appealed the court to prepone it. Let's see. Okay. I'm not saying the immediate bail plea was denied. That's fine.
Okay.
I'm not going to do that.
Let's bring in the BJP spokesperson and Akashdeep Muni. Tom Vadakkan, respond. Let's not get too cock-a-hoop, says the BRS leader, because this is only an interim bail. You should not also suggest that denying bail means there is culpability, there is guilt, etc.
Well, bail is a normal right for an individual. So, I mean, if she gets it, good enough. If she doesn't get it, the judiciary has a strong view on the matter. They have pronounced the fact that she is party to destroying evidence, formatting her mobile phone, and a variety of issues that have been raised. These are serious issues, Rahul. You cannot deny it. And then she has a connect with very important people connected with this investigation. So it is due process of law will be followed. And I think nobody is jumping the gun at this juncture.
Okay.
Let law take its own course.
Let me bring in Akashdeep Saab. Akashdeep Saab, now you see Sanjay Singh got bail and he was very excited. He came out. Of course, you were also very excited that day. And you have a right to be, of course. Who doesn't want to see a long-lost leader come out? And I'm sure you were probably also there, maybe gone to visit him, etc., etc. At some point, he's held many press conferences. He's talked to many television channels. And he's saying that, look, this shows that the entire case is fake. Now, if Mr. Kejriwal tomorrow is denied bail and K. Kavitha is deemed sort of instrumental, as the court says, arguments prima facie point towards her active involvement in the commission of alleged offences. Now, what is this commission of alleged offence? It is the giving, the ED claims of 100 crores in kickbacks, being the face of the South lobby. To whom? to the Aam Aadmi Party. Now, if there is evidence, then this is a problem for you also. This shows that the case is not a fake one. Would you not agree?
See, Rahulji, when the evidence come to the fore in the court, you, me, and all of India will know what evidence Enforcement Directorate has.
Well, can I just stop you there? Muni Saab, I'll read out this order. The order says, the material placed before this court, clause 48, para 48. Please open it, sir. Everyone has this now. Live law ही देख लीजिए, वो भी एक पोर्टल है सर जो काफ़ी लोग आजकल देखते हैं, minute to minute. आप live law पे खोल लीजिए, the entire order is there. Order para 48 says, the material placed before this court. So the material has been placed. In the course of arguments, prima facie points towards her active involvement. ये तो problem है sir, है या नहीं?
मैं आंसर करता हूँ. You are right. The material has been placed in reference to K. Kavitha's bail plea, but when it comes to Kejriwal ji's bail plea, the material has not been yet placed in front of the Honorable Court. First. Second thing is that when it comes tomorrow...
Sir, Akashdeep Saab, I think you are forgetting. आज थोड़ा आप ज़्यादा ही भूल रहे हैं. Can I take you back to a few days when the judge asked the two lawyers to approach the bar, come to the back and show us prima facie, especially the Enforcement Directorate, ki what do you have against Mr. Kejriwal that you want his custody? And it was only after satisfying their curiosity, and I'm not only saying this because they're being voyeuristic or anything, I'm just saying that their intellectual curiosity so that they could pronounce an order, it came out and said, sorry, we can't give you bail, sir. You have to go into custody. तो वहाँ पर भी सर थोड़ा मैं आपको याद दिला दूँ, प्रिमा फैसाई ईडी ने कुछ मटीरियल प्लेस किया, उसको कोर्ट को कंसिडर किया, कोर्ट सेड हाँ प्रिमा फैसाई इसमें मामला है. नाउ सर
देखिए, जो भी कोर्ट के प्रोसीडिंग्स में नोट डाउन नहीं हुआ है उसको ना
ये तो हुआ है सर,
कर सकते. क्या ये प्रोसीडिंग्स में है, लिखा हुआ है?
ये लिखा हुआ है सर, मैं बता रहा हूँ.
नहीं, प्रोसीडिंग्स में नहीं है. ये उन्होंने जो एविडेंस दिखाया वो कोर्ट प्रोसीडिंग्स में नहीं रीड आउट हुआ.
सर आपने ऑर्डर पढ़ा है? इट इज आई हैव रेड दैट
ऑर्डर, क्लियरली पढ़ा है.
अच्छा, कितने पेजेस हैं ऑर्डर में सर? कितने पेजेस हैं?
नहीं, आप प्लीज मेरा जनरल नॉलेज जस्टिफाई ना करें.
जनरल नॉलेज नहीं सर, अगर आपने पढ़ा होता ना, इतने वो डिफिकल्टली नहीं, मैं बताता हूँ, दे आर सो टॉर्चुअस दीज ऑर्डर्स that you want to you memorize each page that you read कहीं भैया फिर से ना पढ़ना पड़े. Anyhow, Dr. Ranganathan, very quickly.
नहीं, आपने तो मुझे बोलने का मौका नहीं दिया, पर चलो कोई बात नहीं.
On a lighter note, I noticed with alacrity how my good friend Tom G was quite kind towards Kavitha ji, because who knows, she might join the BJP tomorrow.
I'll leave it at this.